Hello, I'm Laurie Riedman. I want to welcome you to the second in a series of webinars that we're offering from the Wood Library in 2020. Our goal is to help people better understand how they can advance their charitable interests through estate and financial planning. And I want to thank you very much for taking time today to join us. If you don't know me, I'm Laurie Riedman. I'm the president of the Board of Trustees of Wood Library. This webinar, I believe, is going to last for about an hour. We will address a number of things among those topics of why it's important to have a will or update one, how to seek the expertise of a lawyer and advice on how to do that, how to designate charitable wills, and why you may want to do that, among many other topics. I do want to let all of our participants know and our panelists know we are recording this. And each panelist will be making a presentation, and then there'll be time for them to answer your questions, and we'll be going to a Q&A afterwards. We also are lucky to have a couple of Wood Library staff members in the background, Maria and I believe Cindy's on with us, and they're going to help us moderate and help me manage, and they're moderating the technology behind the scenes. So thank you to them for helping us make this happen. So I think we'll get started. Today we welcome 3 local attorneys who will discuss wills and bequests, and all are dedicated professionals who assist individuals in estate planning and things of this nature from a legal perspective in our community. So first I'd like to introduce Russ Kenyon. He's a partner at the Canandaigua-based law firm Kenyon & Kenyon. Russ assists people with their estate planning needs, including wills and trusts. He's recognized for his understanding of elder law. He also helps clients with real estate transactions and corporate matters. He has a law degree from Wake Forest University and is a member of the National Academy of Elder Law Attorneys, the New York State Bar Association, and the Ontario County Bar Association. He currently serves as the director of the 80 Paris Street and Wilcox Lane Senior Living Residencies. So we welcome Russ.
Thank you.
Also like to welcome Terence Robinson, who is a partner at the newly established firm of Muehe, Maue, and Robinson in Canandaigua. Terence focuses his practice on helping clients resolve business disputes, successfully close real estate transactions, and create tailored estate plans that focus on asset protection and business succession. He has a law degree from Brigham Young University and is a member of the New York State Bar Association. Terence is recognized as a New York State super lawyer for his business litigation and served as chairman of the Town of Canandaigua Zoning Board of Appeals. We welcome you, Terence, to the panel.
Thank you, Laurie. Happy to be here.
And last but certainly not least, we have Amy Boyd-Ertel, is the Vice President and Trust Officer with the Canandaigua National Bank and Trust for C&B Wealth Management. She educates and advises clients regarding trust, estate, and wealth transfer planning. Amy works closely with beneficiaries and attorneys to steward the bank's fiduciary role of estate and trust administration. She's been with C&B for 6 years, and prior to that was an attorney in private practice, focusing on trusts and estates. Amy has a law degree from the University of Buffalo. She's a member of the American, New York State, and Monroe County Bar Associations, and a member of the Estate Planning Council of Rochester. So thank you, Amy, for being with us today. So now that we've met our panelists, let's start. And I believe Terence is going to kick us off and cover the topic of why we even need an estate plan. Terence, take it away.
Thank you, Laurie. And we just want to welcome everyone to this event. And I want to commend the library for making us have the opportunity to do this by electronic means. I think it's wonderful that we can still be together as a community and talk about some of these important issues. So I want to begin with first talking about the elephant in the room. And if we could go to the next slide there. No one really wants to think about end of life. It's a hard thing and it's a hard discussion to have, but it's important. And that's why we're here. There are important questions that need to be answered. And I know on behalf of all the panelists, Russ, Amy, myself, we're here to help you. And we hope that some of what we share may be of benefit for you. So if we could go to the next slide. We'll talk about some of the important questions. As you think about estate planning, there are lots of important questions. What can I do now to ensure that my loved ones are taken care of when I'm gone? How will my medical and funeral expenses be paid? What happens if I'm put in a nursing home or need extended care? What would I like to leave to others? If we go to the next slide, Maria. Who ultimately will take responsibility for your affairs and make medical decisions if you're incapacitated, whether by age, illness, or injury? If you have minor children, who will raise them if they're left parentless? Do you want to limit the use of medical science on your behalf? Essentially, what end-of-life care do you want? What end-of-life care do you not want? And finally, how can you ensure that the administration of your estate does not divide your loved ones and family that you may leave behind or create hard feelings? And so all of these are really important questions. And these are the types of things that drive us as attorneys to try to put together estate plans that will best serve our individual clients' needs. We go to the next slide. So despite the importance of these issues, many people still fail to plan. I was looking at a recent Gallup poll, and they estimated that 44% of Americans said they had a will. So the vast majority do not. And that number is down from 7% from just 10 years ago. And so as you think about why it is that some people fail to plan, maybe you have a plan in place already, and maybe you don't. But for some, it's a fear of time, money, a misunderstanding of what plays a part in the estate planning process. And we hope that today we can help give you some greater understanding of what that looks like, so that it will be less intimidating to either begin an estate plan or update an existing plan. Next slide, please. So when you think about a plan and why you need a plan, a basic estate plan contains 4 essential things, and they can be well beyond this, very sophisticated, or you can even pare this down. But generally speaking, a good basic estate plan will have a will, a power of attorney, a healthcare proxy, and a living will. Without these documents, you won't be able to have a say over what happens to your probate assets. When you die, you won't be able to have someone manage your affairs if you need assistance. You won't be able to have someone make healthcare decisions for you if you're incapacitated, or have your own individual say over that end-of-life medical care. So if we could go to the next slide. We'll talk just briefly about what these different documents do, and we could have entire seminars on each of these. But a will is pretty much understood by most, and it directs what happens to your assets when you die. It can address a whole host of other issues like guardianship of minor children, charitable giving, which Russ will speak about later. But generally speaking, it's the basic plan for what happens to your estate. The power of attorney gives authority to someone to act on your behalf with regard to non-medical matters while you are alive. It's important to remember that when you pass, the power of attorney has no further purpose. Healthcare proxy, this gives someone the authority to act on your behalf with regards to medical affairs. So if you're in an incapacitated state where you're not able to make your own healthcare decisions, the person identified in your healthcare proxy, your agent, would be able to make those decisions for you. And finally, the living will gives some parameters to medical professionals about what care they can and cannot provide you in an end-of-life scenario. For example, you might address in a living will whether you want to be kept alive artificially on breathing machines and artificial feeding, or you may say that you don't want those medical care treatments administered to you. So we can go to the next slide. When should you start planning? It's very important that first statement there. It's never too early. Oftentimes people have in their mind a view that you need a certain level of financial net worth or assets to make estate planning worth it, but really that's not the case. Every person is going to face these medical issues and issues about family care and what will happen to their family when they're gone. And a plan can be tailored to what you need. So it's important that everyone considers their estate planning. If we go to the next slide. Where should you go? Estate planning is incredibly personal because we are each individuals and we each have our own distinct needs and plans and goals for the future. So estate planning really requires a different level of thought and consideration than you're going to get from just visiting the website. The cost of a robust and thoughtful estate plan prepared by a skilled local attorney will probably be less than you think. Oftentimes people think that the cost will be prohibitive, but that's really not the case. So generally, what I always tell friends when they ask is, you need to select a lawyer who you're comfortable with, someone who will meet with you in person, listen to your concerns, and craft a personalized set of documents that are tailored to your needs. We go to the next slide. What I found in working with clients in estate planning is that sometimes just the jargon of estate planning and what happens when someone dies is a little bit intimidating and sometimes an impediment and a roadblock. So I want to go through a couple of things that will hopefully help you understand the jargon a little bit more and make it more accessible. Next slide. So first, the surrogate. When a person dies, there's a special court known as Surrogate's Court that oversees the distribution of their assets. The judge who sits in that court and administers the proceedings there is known as the surrogate or the surrogate court judge. The person who's died is the decedent, and all their assets are collectively referred to as the estate. So we can go to the next slide. There are different proceedings, and sometimes this can get people tripped up a little bit. There are three: the administration, probate, and small estate proceeding. An administration is when there's no will. A probate is when there is a will. And then a small estate proceeding is when the estate contains less than $50,000 in personal property and no real property is owned solely by the decedent. And when we talk about real property, we're talking about land or anything permanently affixed to land like a house or a building. So we go to the next slide. You may hear the word testate. It just simply means when somebody dies with a will. When there's a will, the decedent can control the distribution of their assets through the will and also nominate an executor to oversee the distribution of assets. But the nomination of an executor in the will still requires the surrogate to appoint the executor. And that's an important point. If we could go to the intestate section next. Intestate is the opposite, is when somebody dies without a will. When there is no will, the surrogate will issue letters of administration to a qualified heir, giving him or her the authority to collect and distribute the estate according to a statutory scheme. And that last part is important. The statutory scheme means that the decedent, the person who has died, is not going to control the distribution of their assets because they did not have a will. Rather, the distribution of assets occurs according to the statutory scheme, according to law. Next, we'll talk about fiduciaries. The final topic I want to talk about briefly is the fiduciary. A fiduciary is just a legal term that means anyone who owes another person a duty of good faith and trust. Executors, those are people who are nominated in wills, and administrators, those who are appointed when there is no will, both act as a fiduciary of the estate. The fiduciaries have a statutory right to be paid from the estate for the services they render. And understanding the financial motivation that sometimes comes in with the nomination of an executor is an important thing that you should talk with your attorney about as you nominate an executor and address how that issue may impact your loved ones when you pass. And so in conclusion, my purpose and goal today, before we pass the baton to Amy, was just to set the stage a little bit in terms of why it's important to engage in estate planning and some of the basic details of that. I want to reinforce that estate planning may seem daunting, but it's really not as daunting as you think. There are important issues that you need to address, and a good estate plan will give you the confidence you need to go forward, look at your future head on, and know that you have a plan that will not only take care of yourself as you go throughout life, but will also protect your loved ones when you pass. And with that, I'll turn the time over to Amy.
Thanks. Great job, Terence. And I want to echo Terence's sentiments that it's so nice to be with you all together today. I know it's a little unconventional, but it's great that we can all be alone together and spend our time in quarantine learning something new. So when we got together and started planning what we were going to be talking about for estate plan, one of the things we want to touch on is, how do you know when it's time to review or update your estate plan? You know, you've done all of this work, you met with your attorney, and this is not a set it and forget it kind of situation. You want to continually go back and double check to make sure that your estate plan is still effectuating your wishes appropriately. So there's a general rule of thumb that you should look at your estate plan about every 5 years. Just pull it out, make sure that it still matches your wishes. I think in reality, we know, Terence and Russ probably know that people don't like to go to the attorney like they continually go to their hairdresser or their dentist. So this is a hard rule to follow, but it is a good idea to, try and take it out about every 5 years. If you can't remember to do that, there's also some triggering events in your life that should prompt you to pull out your estate plan and revisit it again. And in general, those key events will be things that are related to the people in your estate plan and the assets that you're planning with. So for example, if you have the birth or death of a close family member, that should prompt you to review your estate plan. Like the death of a spouse, that's a good time for you to go and check in, and your plan is probably going to change. Or if you have the birth of a child or a grandchild, you'll either want to provide for some kind of guardian or perhaps create some kind of request for that grandchild or trust some kind of gift to them. So that would be like a change in the people to your estate plan. Another triggering event would be divorces, marriages, and especially remarriages and second marriages. We live in a day now of Modern Family, Brady Bunch. There's these combined blended families. And whenever you have a situation where there's a second marriage, it's a great idea to, again, look at your estate plan. You want to make sure that you're providing for the people you do want to provide for and the people you don't want to provide for. So when there's changes in the people that are involved in your estate plan. Another good time to check on your estate plan is when you have changes to the assets that you're planning for. And so this can be anything like a change of your employment. Perhaps you've sold a business. You don't need to include it in a plan anymore. Or you've retired. Or maybe you are just in an area of unemployment and you have different assets that you're going to be planning for. That's going to change the assets that you're really addressing in your estate. And any other large financial changes should really prompt you to pull out your estate plan and review it again. So if you receive an inheritance, perhaps from your parents, it's going to be something larger that you didn't originally plan for. Any other major windfalls, or in the same token, any large losses. You're not planning with the same, assets as before. So when there's changes in people or changes in assets, those are great times to review your plan. Also, another good time to review your plan is when there are tax law changes. Now, we don't expect anyone to be an expert in knowing tax laws. That's what, your trusted professionals are there for. It's more keep your ears open. And if you hear about things, tax law changes, you hear about it in the news, it's a great time to go visit whoever your trusted professional is, whether it be someone at the banks, a financial advisor, an attorney. Go back to them. This is something that we do day in and day out, so we understand the nuances and we follow it. So if you hear about major tax law changes, it's probably time to check in. Just as an example for this, it can really change your structure of your plan. So for example, in 2000, the New York estate tax, meaning you had to pay an estate tax in New York if your estate was more than $675,000. Now in New York, you're not considered to have a taxable estate unless your estate is over 5.8 million. So that's a huge gap between those two numbers. And if you had tax planning in your estate, you're going to want to revisit it. Maybe you don't need to have the tax planning you did in 2000, or maybe you have a larger estate and you need to do more complex planning. I'll also note too that state laws are different from state to state, especially when it comes to estate taxation. So if you're doing anything like moving from one state to another, that's also a good time for you to check in and find a local attorney who can help advise you about the local rules. So that kind of covers when you should be looking at your estate plan. Something else that we did kind of want to discuss is how do you revise your estate plan? So I just want to remind you that a will and a revocable trust can always be changed. Not static, you can continue to change them, and they're not final until you're dead. So go ahead, it's fine to revisit and revoke them if you need to. If you have a will and it's only a simple change that is needed, you can execute what is called a codicil. So this is a simple addendum that goes onto your will that addresses a specific clause. It removes and replaces a clause in your will. If you have something like a revocable trust, it's a simple amendment can do this. Now, as it's not a rule per se, so Terence and Russ could disagree with me on this part, but in my opinion, if your change is going to be more than a simple clause adjustment, or if you've done multiple codicils and amendment, I think it's best practice to either restate your revocable trust or amend and create a new will. And I only say this is because you may want a clear estate plan. If you're going back and you're reviewing it, it's much easier to read one document than to piece together 5 different pieces that, revoke, replace, remove, change all your provisions. It's going to be easier for you to read. It's going to be easier for your beneficiaries, easier on your attorneys, easier on your executor to understand what the plan is and for it to be clear without any kind of confusion. So depending on how much your changes are, it may change how you actually do the revisions. I also wanted to give a caveat here. Please see your attorney to make any changes. Don't try to do it yourself. We've seen lots of horror stories with people trying to use, LegalZoom to do their own changes. Don't attempt it yourself. These are legal documents and you want to make legally binding changes. So I've seen things like people take their will out, they want to change a specific bequest. They cross off gift to my son for $500 and write in $5,000. That's not going to be legally binding. The courts aren't going to honor that. So if you really want to change or revise it, please go see your attorney to do so. And I know people are, hesitant. I think Terence used the word daunting to see an attorney and do an estate plan, but it's almost always much cheaper to see an attorney and do a proper estate plan than to pay for attorneys later on for different family members that are fighting and arguing about a will. So, if you're cost conscious, doing a clean plan at the beginning is the best way to protect yourself and your beneficiaries later on. So I think that covers my portion about when to revise people changes, asset changes, moving and tax changes, and how to do revisions to wills. So with that, I'll kick it off to Russ.
All right, well, I am here to talk about charitable giving. Can be just one part of an estate plan. So let me kind of jump right in. There's really 2 different times that you can make a charitable gift. In my practice, I've almost everything I do, it seems like I break everything down into 2 different time periods, 2 different things. The 2 times you can make a gift are during your lifetime or after you die. An example of gifting during your lifetime from an estate plan point of view would be the creation of a trust, for example. You create a revocable trust and you make a beneficiary of the trust a charity. Another example of a lifetime charitable gift would be there are these charitable remainder trust products. I don't want to get too deep into that. Happy to answer questions about it. But for example, you make a single premium payment on a product that'll pay you an income stream, and then on your death or on the termination of the trust, a charity that you designate will be the beneficiary of whatever's left, the remainder in the of the remainder of whatever that product is. And there's some tax benefits that I'll talk to in a few minutes. The other time that you can make a charitable gift would be after your death. Now, there's a couple different ways that you can do this. One would be to make a specific gift, a specific bequest, or a specific devise. It's kind of interesting. A bequest traditionally has been a gift of personal property, and a devise traditionally was a gift of real property. Now it's pretty interchangeable, and we'll even say in a will, I give, devise, and bequeath. So I'm giving you all these different things. But you can make a specific gift in a will or in a trust. You can say, I give $1,000 to my church, I give $500 to my college, or something along those lines. You can also make what we call a remainder gift. And again, this can be in a will or it can be in a trust. And you can say, I give this to so-and-so, I give that to so-and-so, and whatever's left, I split between my church, my college, and the hospital. You could, during your lifetime, take out a life insurance policy or an annuity or some other financial vehicle, and you could make a charity or a number of different charities the beneficiary of that. So you're taking action during your lifetime, but the gift takes place after you've passed away. And again, like I mentioned before, you can have a charity, the remainder beneficiary of a charitable remainder trust kind of a product. When people sit with me and they talk about wanting to make a charitable gift, I like to talk with them first about, why are you doing this? Why do you want to make a charitable gift? And there's a couple different reasons why people might want to make a gift to a charity. One is they just have a charitable intent, or they have a charitable wish. The Red Cross has been important to me during my life. The YMCA is important. The library has done such a great thing for our community. I really want to give back, and I want to give back on my death. Another reason that people will make a gift is a tax benefit. Now, there's really, again, two major tax benefits that I can think of when you talk about a charitable gift. One is an income tax benefit. The income tax benefit I see mostly along the lines of that charitable remainder trust. You make a designation now and you're able to take some income tax benefit over a certain period of years. That's something that happens. It doesn't happen very often, but it's something you can do. Another significant reason to make a charitable bequest would be to avoid estate taxes. Now, Amy already mentioned the New York State estate tax limits this year are $5.85 million. The federal government will let you pass $11.58 million before they start taking any tax out. And they'll let husbands and wives share that, or spouses share that. So you can do $24 million almost before the tax man starts taking a bite. My experience has been that there is less of an estate tax avoidance reason for charitable gifting than just the charitable intent. Another reason that people will make gifts, they got nobody else to leave the money to. I've had some clients that don't have any family at all. So, hey, who should I leave the money to? And I'll say, hey, how about your church, or how about your college, or how about the hospital, how about the library, how about the whatever? And they go, oh yeah, that's a good idea. So what are some things to think about? Well, one of the things that I think you should be thinking about if you're talking to yourself about making a charitable gift is, how much of a gift are you talking about? Are you talking about a nominal amount? Hey, I want you to say a funeral mass for me, or I want to buy the Bibles in my pew, or I want to buy a series of books in the library, or I want to have a monitor named after me in the in the stacks, whatever that might be. If it's a tiny nominal amount, if you want somebody to say a funeral mass for you, you can certainly say it in the will. My experience has been more often than not, just get somebody in the family to promise to do something like that. If you're going to do $500, $1,000, something like that, that's one direction that will go, and it's a little bit low key and a little bit easier to kind of put that into our documentation. The other type of amount that you may be making a gift of could be a significant amount. Maybe you want to endow a scholarship. let's say a scholarship at the high school, a scholarship from the high school to a college, a scholarship at a specific college, anything along those lines. Maybe you want to set up an endowment. Maybe you've got the ability to leave enough money to an institution where they can invest that gift and utilize the gift for certain purposes. So I want to know, when I get talking with you, how much are we talking about here? Are we talking about a little bit, or are we talking about a lot? Then I'm going to ask you, I'm going to chat with you about what kind of entity are we talking about? What have you thought about? Are you thinking about your church? Are you thinking about the library? Are you thinking about your school? If you're thinking about your school, are you talking about a college or university? Talking about a high school or a school district? Talking about a private school, a parochial school? Are you talking about a hospital? What kind of charitable entity are you looking at? Then within different charitable entities, there are different kind of geographic regions. Do you want your gift to be utilized locally, regionally, statewide, or nationally? You may want the American Heart Association to be a recipient of your estate, but you want the funds used locally. And we've got ways that we can do that. Sometimes people say, hey, I want to leave it to, the such and such political party or something along those lines. That's all well and good, but when you are talking about a charitable gift, it's important to consider if the gift itself is to a charity. If you're looking for tax breaks, tax deductions, there's certain factors that have to be in place in order for the gift to qualify. In some entities, or a lot of entities, you're not eligible for an actual deduction based on the gift. And that's something that any attorney that does this is going to be able to chat with you about. You can also talk with accountants about things like that. I like to go and make sure that my clients are thinking about the purpose of their gift. I have had situations where clients have said, well, I want to give this money to my church because they need a new roof. Okay, and we do that today, and then the person who's drafting the will doesn't die for 20 years. Within the last 20 years, they put a new roof on. Now, if we had drafted our documentation in such a fashion where the gift was restricted so that the only purpose you could use these funds for was to put a new roof on the church. The church had a great roof, but it didn't have enough money to keep the lights on. It didn't have enough money to, pay the pastor or whatever. Then you've got a problem. So I always talk with my clients about what's the purpose. Would you be okay with a general purpose? How do you want this managed? Who do you want this managed? A lot of times, a pretty common phrase that I'll put in a will is, I leave X amount of money to such and such a charity to be utilized as the governing body deems fit or they deem responsible. Now, if you say, listen, this money is to be used every year to give a graduating senior $500 to help pay for their books next year, well, we certainly can do that. We would certainly, make that provision. But I want you to think about things that could happen between the time you draft the will and the time you pass away, and how can the entity best utilize the funds that you've left them. Should you contact the charity that you're considering during the estate planning process? Again, I think that's going to depend a little bit on what you're talking about. If you're talking about $100, probably not a huge deal to reach out to the entity and say, hey, I left you $100 in my will. But if you're talking about a significant gift, I think it's a very good idea to talk to the entity. And there's a couple different reasons. One of the reasons is, what entity do I really want to make the beneficiary? I've had a lot of clients leave money to the college, the Finger Lakes Community College. The college is not the entity that actually receives and manages bequests. There's an entity called the foundation. So anytime a client comes to me and says, I want to leave money to my college, I want to leave $5,000 to my college, I call the college and I say to the college, hey, I've got a client who's thinking about doing this. Who should I leave it to? This is what they want to do with it. They want to set up a scholarship. They want to They want to endow a professorship. They want to endow a coaching position. They want to buy new diving boards, whatever. And we can work with the entity to try to find the best way that they would like to see it structured, and then make sure that that fits with what the client wants to have. Let's say that the entity or the client wants to make a restricted gift. I want to give this money, but the only thing they can use it for is to pay the tuition for people from Ontario County. Well, I'm going to reach out to the entity and say, will you accept this kind of gift? Hopefully they do. If they don't, I go back to the client and explain to them, you know, I chatted with the college. This is what they said. Maybe we can structure what you're trying to do a little bit differently. Then I also like to check to make sure that the money, the gift that we're contemplating goes where you want it to go. So if somebody wants to leave money for the American Cancer Society, but they want it utilized for research in the New York State area, I check with them. Can you do something like that? Always a good idea in my mind when you're talking about more than just a nominal gift to communicate with the entity that's going to be the eventual beneficiary to see that we can do what we're trying to do. A trend that's kind of going on now, and I think it's cyclical because I've seen it in the 26 years I've been practicing, probably 3 or 4 times there's a push for this. The charitable entities are looking for donations. They're looking for people to name them in the will. So if I go to a college and say, hey, I've got a client that wants to leave you $300,000. Oh, can we put their name in our magazine? Can we do all these different things to give the person who's drafting the will some current recognition, but at the same time execute a little bit of a management, or not a management, a marketing strategy for the entity itself. The last thing I'll talk about, and then I think we're going to open this up to questions, are just kind of some general, you know, other things to do with charities. Some people want to know, well, who's looking out for the charity? In New York, the Attorney General's office is the entity that is responsible for making sure that charities' rights are protected during the surrogate court process that Terence had talked about. And anytime, frequently, we will have to get involvement with the local Attorney General's office in order to get them to sign off on something or to get through the whole process. And then I guess the last thing I'll really mention kind of specifically before we get into questions, some people have asked, well, what if I you know, leave money to a specific charity and that charity is not around anymore? The charity itself has gone out of business, or maybe you left money to eradicate polio, and polio's you know, not an issue anymore. There's a legal concept called cy-pres, and cy-pres is a concept where we can get, probably with the Attorney General's involvement and the court's involvement, look, this guy passed away and he really wanted to leave money for research into this particular area. That's not an issue anymore. We think maybe this would be a good issue and we can get everybody to sign off. Or she left money to this charity that looks after this particular interest. That charity is not around anymore, but this charity does handle that particular interest. So if the intent that you had at the time you drafted the document has changed between the time you draft the document and the time you pass away, we do have a process where we can still utilize the funds that you've earmarked for that purpose and try to fit them into another category. So that's about 15 minutes worth of Tommy gun talk on charities. I think maybe it would be a good time now to open it up to questions. Laurie?
Thank you, Russ, and thank you all of our panelists. I do have several questions already, but we do have some time if you want to write in a question. Here is one question that came in, and actually 2 different people asked this. I'm not sure who to direct this to. Maybe, well, I'll let you guys decide. The people have wills and trusts set up in another state, but they're now residing in New York State. and wondering, do you modify the existing plan? Do you need to start from scratch with new New York State wills and trusts? What's the best thing to do if you have something set up in another state and you now are in New York State? Who would like to answer that? Terrence, you want to
Yeah, I'll
answer?
jump in on that quickly. Under New York law, they will recognize a will executed in another state so long as it was executed in accordance with the rules of the state where it was executed. So if you lived in Florida and you did a will in Florida, as long as you executed it in compliance with Florida law, New York courts will recognize it. It will be processed pursuant to our procedural rules here, but the will is valid. Now, that's a totally separate question. I might kick this one to Amy because she talked most about this, is when, though, do you need to look back at that will? You've moved states. Obviously, there's been a lot of intervening life stuff. Do you really want to go forward with a will that you did in another state however many years ago? Maybe Amy can speak on that a little bit.
Yeah, I think it's a great time to check in because likely, your assets change, you have a different house. So it is a good time to check in. And I think too, your wills are still valid, but you want to make a connection with a local attorney so that you have someone to go to if you do need advice. You want that trusted professional on your side. And also to understand that state law, in terms of some of the defaults, some of the process, some of the procedure, is different from state to state. And wherever you pass away, if you pass away in New York, the rules of New York and the laws of New York are going to apply. So just so you understand how your will is going to be administered and what other default rules may be applicable, I do think it's a good idea to at least check in with an attorney. It may be that your current will is fine and you don't need to make any changes, but I would at least establish our relationship and review the will.
I'd like to pitch in here and talk about one of the things Terence talked about with healthcare proxies, living wills, and powers of attorney. The will, more likely than not, the will that you drafted is going to work here in New York, and the only reason to change it, in my mind, would be if your wishes change, or that's the biggest reason to change it. But the healthcare proxy, out of my experience or my opinion, is the most important out of those 4 documents that Terence talked about. Healthcare proxies can be recognized if it's drafted in a different state, if it met the requirements in the other state. The living will, same kind of thing. But if you've got the opportunity while you're healthy and while you're competent, while you've got the physical and cognitive ability to change it, sometimes if you're going to be in a new state, having a document that looks the way the providers expect it to look, avoids having to get the general counsel of the hospital involved, or getting the ethics committee involved, or getting the charge nurse or the attending physician or somebody else involved. A lot of times having the document that looks the way it ought to look can just make things a little bit easier down the road. And any competent local attorney is going to be able to say, I don't think you'll have a problem with this, or yeah, this one is something nobody's ever really seen before around here. Why don't we think about doing a new one, or even download the New York State Department of Health healthcare proxy. So sometimes just the functionality is a reason to make a change, if that's something.
There was a similar question that maybe I don't know. Can you guys hear me now?
Yep.
Maybe you can answer. Someone was asking, given what we're living in right now, the coronavirus situation, and how quickly things can change in the matter of health. 2 questions came in. How quickly can we create a will if someone gets ill and maybe doesn't have one? Can you even create and sign one if the person is being currently hospitalized? And the same question with creating and signing a healthcare proxy or a living will in a situation where someone is ill and doesn't have one.
Well, let me jump in on this. Some of the executive orders that Governor Cuomo has signed address those issues. We as attorneys are able to supervise the execution of wills remotely. And I have had a couple since this has started, and I've got a couple scheduled, where I will be doing the will execution ceremony by Zoom, just like we're doing today. Healthcare proxies, same thing. Powers of attorney typically are notarized. We can notarize documents remotely now as well. There are requirements. It's not a blanket remote notarization like some other states may have. But, the legal profession has kept up with the need, and the law, thankfully, has changed to the point where we're able to do things remotely. It takes a little bit longer because we're not sitting right next to each other, but we're doing a pretty decent job being able to get stuff out the door and get it done.
And I just add, I think for all of us here as panelists, when a client is in need and there is an exigency, we will meet that need. And if you need one done quickly, we will help you get it done.
One question is, all of you are attorneys, and we assume you can all write wills. Amy, if you're associated with the bank, but you are an attorney, could someone go to you and actually have you create a will?
Unfortunately, I can't. My capacity with the bank is a trust officer, so I can educate, I can advise, and I can work with clients to help them discuss their estate plan, but I can't do the actual writing of the will. I would sit down with someone, discuss with them, and then I'd pass them off to another competent trust and estate planning attorney. But I can help save on billable hours, but don't tell Russ and Terence that.
I want to point out that, there'll be a lot of times where we name the bank as a fiduciary, and we will work with the bank in order to make sure the documentation meets their needs and the client's needs. So working with the bank, with the trust department, with the wealth strategies group, and the attorney draftsperson is a pretty important part of the job.
Definitely. So we're often named as executor or trustee under wills. So we work with the families and work with the attorney to actually effectuate those wishes. So if we're ever named in a document, we're happy to sit down with you and tell you how we would actually administer it and what the process would be with us working with your family and working with the attorneys.
Thank you. Question, this person has a will but needs to make changes. The attorney who originally wrote it up is no longer available. Can a new attorney just make changes to the existing will, or do they need to start from scratch? I'd like to take that.
That's a really good question, and one that every practicing attorney in this community sees regularly. Their parents or grandparents or somebody did a will 20, 30 years ago. The lawyer may be dead. The lawyer may have moved on. First it's, well, where is the original will? That's always an important question for you to think about when you're drafting documents, is where will the original will be kept? Because the original will is essential to get into the probate process. But in terms of, just doing a new will just because an attorney is no longer here in the community, that's not the reason to do a new will. Like Amy talked about, and Russ has mentioned it as well, if there's a significant intervening change in your life or a change in your wishes, that's when you should redo a will. If your lawyer's retired, I would definitely make sure you have the original before they're gone and out of town. But just because a lawyer's moved or retired, that in itself doesn't mean you need to do a new will.
Thank you, Terence. Can anyone provide a brief overview of what a supplemental needs trust is?
Sure, that's a big part of my practice. Supplemental Needs Trust, or an SNT, it's a lot more descriptive than you might think it is. The purpose of the trust is to supplement the needs of the beneficiary. Now, that's a pretty Weisenheimer response to the question, but let me give you an example. We'll use supplemental needs trusts in Medicaid planning, for example. If you have an intended beneficiary of a trust, and that beneficiary is or has a chance being a recipient of a governmental benefit such as Medicaid, it's not unheard of, it's not uncommon for the beneficiary to receive an inheritance and then get kicked off of their benefits. I had a client left everything to her daughter. When she signed her will, her daughter was healthy, no problems. After she signed the will, but before she died, her daughter had an accident, acquired a disability, got SSI, got Medicaid. Mom died, left her some money. She got kicked off of the SSI. She lost her Medicaid. A supplemental needs trust is a vehicle to hold those funds and to distribute those funds in such a fashion that the benefits that they're receiving from the governmental entity or whatever benefit program there is, those benefits won't be interrupted. I will use it testamentarily, hard word to think about how to say, as part of a will, or we can create a supplemental needs trust during your lifetime. And sometimes probably the most common beneficiary of a lifetime supplemental needs trust would be a cognitively impaired child. And as they turn 18 and you may be looking for them to be Medicaid recipients and maybe SSI or SSI beneficiaries, you want to set up a trust where funds can be held without impairing, without impeding those benefits that they're entitled to. And I could talk for another hour about it easily. So
Well, we don't have an hour, but thank you, Russ. And we will be, everyone, we will be sending resources from each of the panelists to you in the form of an email following the program. So if you have specific questions or want to get in touch with any of our panelists, you are certainly welcome to do that. So we will be providing that. Another question that came in, which semi might have been answered, but I think this is slightly different, so I'll leave it to the experts. What resources, materials are available to assist when starting to prepare an estate plan? We'd like to begin preparing, but during this pandemic, obviously physically meeting with a lawyer is not an option. How would you do this?
I think the first thing I would do to start to prepare is create a list of your assets, because that's going to be one of the first things the attorney looks at. So go through your assets. What do you own? And how do you own it? Is it owned jointly with a spouse? Is it held only in your name? Is there a beneficiary designation on it? So I think listing and identifying the assets you're planning for is definitely the first step. And then I also think having a family discussion is very important when you're starting to do this. You know, you have to ask yourself the tough questions, and as comfortable as it may be, I mean, you have to talk about if someone in your family passes away and tell them off one by one. So, I mean, what happens if a spouse dies? What happens if a child dies? What happens if someone predeceases you? And go through all the permutations and think about that. Also, I think it's a good idea to start deciding who can handle different responsibilities, like in the power of attorney, who would be able to handle your financial affairs for you. And the same thing if, you know, there's an executor under your will, who would be able to follow your wishes and handle those affairs correctly as you've directed. So I think it's really brainstorming sessions and making sure that you have everything in order. And normally when you make an appointment with an attorney, they provide something called an estate planning questionnaire or something like an intake form. And they'll send that to you before you meet to get an idea of these assets and get an idea of these wishes. So you can prepare by collecting that information ahead of time to make it easier to fill that out for the attorney.
I think it's just important to reemphasize what Russ was saying. The governor has made it possible for us to continue to help you prepare, and we can even do will executions during this period of the pandemic. So I wouldn't delay it and think that, well, there's nothing that can be done right now.
Might be to Russ, but it's about charitable trusts. Do you have to have a lot of money to create a charitable trust? And is it a charitable trust that allows our giving and funds to grow and benefit the charitable organization of our choice?
I'll start with this, but I may throw it to Amy in a little bit. And one of the reasons for that is you don't need a whole lot of money. There are a couple different organizations in this region. Charitable intent is just the foundation of their creation. One of them is called the Finger Lakes Area Community Endowment, or FLACE. FLACE was started by George Hamlin and some people at Canandaigua National Bank, and it's a great tool to use when you don't have $250,000 that you want to start a charitable purpose with, but you may have 5 or 10 like-minded friends, for example, that want to contribute to somebody's education fund or something along those lines. I'm going to pitch it to you in a second, Amy, but one of the things that I also want to say is sometimes you may, from a trust standpoint, sometimes it just doesn't make sense to have the trust. The expense of managing the trust may be such where just give them the darn money instead of setting up the trust. And working with an attorney, working with wealth strategies people, working with financial advisor can help you kind of find where that line is as to where you ought to do that. Just in the interest of full disclosure, there's an organization in Rochester, the Rochester Fund, which is just like FLACE, except it's up in Rochester. But FLACE is a great organization where we can use a little bit of money and get some like-minded people to be able to benefit some charitable intent.
Yeah, they're the endowment funds basically are alternates to charitable remainder trusts. So FLACE, Rochester Area Community Foundation, you can create an account and overall endowment, FLACE or the Rochester Area Community Foundation is the overarching governance of it. And then you can have smaller accounts in any amounts for purpose. So that's the endowment is basically the charitable trust itself. If you do decide that it's going to be a more sizable gift and you're going to be doing something like a charitable remainder trust, the trust itself would hold assets that could be investable. So in our group, we have actual accounts that have stocks, bonds, securities, everything like that in it that continue to be managed. The income or an annuity stream comes off of those assets paid to you, and upon your death, then it goes to charity. So it can continue to grow and be invested. It's not just sitting there in any kind of checking account. So if it is large enough to be investable, that is something that we would do.
An interesting thing on this topic as well is I was recently meeting with a client where, maybe they weren't quite enough funds to create their own trust. And so we talked through a couple of these different things, and ultimately the client decided, well, let me just make the gift now. And when he presented that gift to the not-for-profit, a local not-for-profit, they offered him a seat on their executive board. And now he's got a much larger role in this not-for-profit that he feels so strongly about. And it's not something that he asked for or sought out, but kind of a nice little benefit of his giving.
5 minutes past the top of the hour. That hour went very quickly. Thank you all, our panelists, for sharing your expertise. Again, we will be sending out an email to all those who registered for this event with your details and any information that you provide us to pass through to them. We will be hosting a final program in our 2020 financial series on donor-advised funds, and it seems like from the end of our time today, there's interest in that, so that's great. So you can look for more information on this topic and signing up for that. Really do appreciate everyone being with us. Thank you so much. So happy that you hung with us with the technology. We're all getting used to doing these things virtually. Stay tuned to the library Facebook page, to our website. Our librarians and staff are continuing to add new online resources as we continue to stay safe in our homes, and we and the library continue to serve our mission of serving you. So thanks again to all our panelists. I hope you have a great day. So enjoy, everyone. Thank you.